Thank you very much. Hafaday, welcome to the Guam Congress Building. The Committee on Health, Tourism, Historic Preservation, Land, and Justice is now called to order. Today's Monday, May 20, and the time is about 2:08. Notices for this informational briefing were disseminated via email to all senators and all main media broadcasting outlets on May 13 and May 17, 2019. The notice was also published in the Guam Daily Post on May 13 and May 17. Today, the committee will hear a status update from the Judiciary of Guam and others regarding the Sex Offender Registry and risk assessments for release and sentencing of criminal sexual conduct offenders. Before we begin, I'd like to acknowledge the presence of my colleagues, Senator Amanda Shelton, our Legislative Secretary. Senator Shelton, thank you for being here, and Senator James Moylan. Thank you for being here, Senator. So we have representatives from the judiciary. Thank you for being here. Steve Hattori, if you'd like to join us from the Public Defender's Office, you're welcome to, please. And Ms. Karina Farron, thank you. Oh, I'm sorry, Karina Farron is also here. So a few weeks ago, we had a roundtable, and many of you were present, regarding sentencing, risk assessments, therapeutic interventions, and release for criminal sexual conduct offenders. We confirmed at that time that despite the option of a sentence of life imprisonment without parole, many criminal sexual conduct offenders are being released due to lesser sentences or parole, and they're being released without any assessment as to risk of reoffending, and in almost all cases without any treatment to deter them from reoffending. The Bureau of Statistics and Plans compiled information from the Judiciary of Guam's, for their draft FY 2019-2022 Strategy for Drug Control, Violent Crime, and Criminal Justice System Improvement on the Sex Offender Registry. In 2017, there were 1,093 convicted sex offenders, according to the Bureau of Statistics and Plans, on the registry. 1,093. 583 were level 1, 132 were level 2, and 378 were level 3. This is in 2017. So this report noted that the Judiciary Sex Offender Registration Management Office has approximately 92 sex offenders managed by 1 probation officer and 492 managed by 3 case managers, with approximately 543 unsupervised sex offenders. The Department of Corrections Parole Division has 74 sex offenders managed by 6 parole officers, in addition to the other cases that the parole officers manage. On release, the criminal sexual conduct offenders must register on the Sex Offender Registry, but are otherwise largely unmonitored. Department of Corrections provided information to our office that identified 12 individuals who committed a criminal sexual conduct offense, again, while either on parole or after they completed their term of parole since 2015. I would like to begin with the judiciary. I had asked, if you could provide more background on the Sex Offender Registry, criminal sexual conduct offenders, how they are required to register, and their classifications. They're classified as level 1, level 2, or level 3, and if you could explain that for everyone that's listening. And it also says, according to the statute, that offenders must appear in person once every 90 calendar days to verify and update their registration information for the rest, well, I guess for different time periods depending, and you'll explain that. So level 1, according to this, they report for the rest of their lives. Level 2, offenders appear every 180 days to verify and update for the rest of their lives. And level 3 must appear once every year to verify and update their registration information for 15 years. So we've asked the judiciary to be here because according to our statute, it's the judiciary that is education information and supervises the release of the verified information, and they are doing this via their website. So if we could now hear from the judiciary. If you could, Danielle, if you could introduce your team, that would be great.
Thank you, Senator. With us this afternoon, of course, myself, Danielle Rossetti, the Clerk of Court. I have Dr. Juan Rapadas from our Client Services and Family Counseling Division, our Acting Chief Probation Officer, Ms. Tricia Suzuki, and Mr. Ruben Payumo, who is head of the Sex Offender Registry Office with the Judiciary. And before we get into the specific questions regarding the Sex Offender Registry and how it's managed with respect to the different levels of the offenders, I do want to point out that as from our last roundtable discussion, we went back, and with you, in front of you today, that we have provided is more data. Case summary, as we mentioned, from the 2016 to 2019 was the time period that we were looking at examining the landscape of criminal sexual conduct offenses that are brought before and adjudicated before the Superior Court of Guam during that time period. You also have with you, as you alluded to, the Judiciary of Guam Sex Offender Registry data, that chart that shows from 2010 to 2018. We've added 2018's data, and as you mentioned, in 2017 there were 1,093 registered sex offender cases. Now it's important to note that that's cumulative over the years, so there weren't 1,093 in 2017 alone. You have a graph of sex offender registry case status by levels. And then finally, you have the Sex Offender Registry repeat offenders as of May 15, 2019. And so perhaps we could start with Ruben to kind of maybe answer some of the questions that you kind of want to know about the Sex Offender Registry, if
Danielle,
that's helpful. Yes.
we're looking at this
Correct,
report?
yes.
Could you just talk, where here does it show the repeat?
The repeat offenders is a separate graph chart.
Oh,
It's
that.
this one, and that'll show you during the time period from 2000 to 2018, the number of sex offenders that were repeat offenders. So this is what it would show if they had a prior criminal sexual conduct conviction and then later picked up a new conviction, then that's when they show up on this list.
Thank you very much. I'd also like to welcome Chief Kanata from the Department of Corrections. Thank you for being here. I know you're very busy over there today. I appreciate you being here. Okay, please, Mr. Fayumo and Chief Suzuki.
Yeah, thank you, Senator. Yeah, basically we meet with every sex offender that's convicted of CSC. I'm sorry. Okay. Yes. Yeah, we make it a point to meet with every sex offender that we register. The majority of them come out of Judiciary of Guam courts. And so after their sentencing hearing, that's when we meet them and sit down with them and explain their duty to register to them and have them sign all the forms related to the registration process. We also take their photo and gather all the information, and we inform them of their classified level and when they're required to report back to our office. Level 1s are once every 90 days, level 2s once every 180 days, and level 3s are annually, once a year. Now, if their information changes within that time period, they have 3 days to come in and report that to us at our office. And so basically, that's the process that we use to monitor these individuals. The ones that are sentenced to serve time at DOC, we register them after their sentencing hearing, and then of course, we meet with them after they're released, and we continue the process. Most of them get sentenced to parole afterwards, and so they're under parole supervision for how many years? But once they complete their parole supervision term, they fall under our registry monitoring system, where they're reporting in based on their level. Same thing with clients that are placed on probation. They're directly under our supervision, so they report in once a month during their probation term. Once that probation term ends, they're required to report in based on their level as well. And so we keep monitoring them for the length that they're supposed to be on the registry, which is with the level 3s, 15 years now, level 2s and level 1s are lifetime. Now, there was some talk earlier, I believe, on the radio about 500-something unsupervised sex offenders out in the community, and that wasn't really accurate. When we classify an offender as unsupervised, that only means that they're not on probation or parole, but they're still being monitored by our office. So I just wanted to make that clear because it almost sounds as if they're not being watched by anybody while they're out in the community, but they actually are monitored by our office.
Isn't that how they were described in the Bureau of Statistics and Plans report?
Yes, previously we described them as being registered, but because everyone in the registry is registered, regardless if they're on parole or probation, we wanted to change that to be more clear about what their actual status was. And unsupervised seemed to be the most accurate, but I think out in the community that could be a little confusing. So we can stick with registered, but we only did that because everybody's registered, but within the registration, we all have different classifications.
All right.
Yeah.
Okay.
Okay. We also are responsible for registering individuals who are convicted in other courts like district court, military court, or courts from off-island in the mainland. But the process is still the same. We meet with them, try to get their conviction documents, explain what our process is here in Guam, and we go through the same process, and that's where we get the rest of our clients that are on the registry.
Do you go out and verify their information that they have provided to you? So it's pretty much a self-reporting system. They come in, they report.
Yes.
Do you ever go out and verify that what they've said is accurate?
Yes, we do. We've established a process where we go out with the U.S. Marshal's Office and parole and all our law enforcement counterparts. We try to do it as much as we can. We did it 4 times in 1 year. 2 years ago, last year it was 3 times. We're going to try to get back to 4 times. But we go out and make our checks just so that we can be proactive about the information we're reporting on the website. So I believe last year we made over 400 checks. This year we're already above 200, but it seems like we need to do a lot more just based on the number of changes that are being made when these registrants make changes to their information. Yeah, it's always best to verify before we get that thing uploaded to the website. And for the most part, they report accurate information. There may be a few incorrect information, but for the most part, they're reporting accurate information because that's what we're finding out when we're out there verifying the information. And this is a process that's been ongoing for years, so they're already, I guess, under a routine. They know what to do already, come and report, and then.
Okay, so they're required to report addresses, employment information, and vehicle registration, driver's license, right? They show you if they have one?
Yes.
And, all right, but for me, I'm most concerned the addresses. I guess it's what I thought the intent of the registry was for people who live in the area to know who's in their area, and also for law enforcement to know where to find them if something's going on that they might be needing to find them, right? Or so, all right. Well, I'm glad to know that. So you've been doing, when you go out, let's say 4 times a year for these checks, it's estimated that you might do over 200 checks. Is that 200 individuals, or you're checking some individuals more than once?
Yes, we're checking some individuals multiple times. If we're in an area where we're checking a new residence that was reported, and we want to make sure that the offender actually stays there, if there are other offenders residing in that area, we'll stop by and check on them too as well. Make the most out of our visit.
All right.
But our priority are all the new addresses that are reported. If we've been to a house several times already, if we're in the area, we'll check it, but our priority is the new addresses that are reported to our office. So if we want to make sure we know where that house is and that the offender actually lives there.
All right. Of the 543 that reported in 2017 as unsupervised, meaning they're not on parole or probation, but they're still reporting on the registry, what level were they? Are we able to tell that from this report? I guess the levels are on one category, and then whether they are on parole or supervised is in another one. So
Yes.
I'm not able to tell. Are you able to tell me, for example, how many who are unsupervised are on level 1? That type. Break it up by level.
I can break that down, but I don't have it with me right now. But I
Okay.
do want to clarify that number, the 500
All right.
unsupervised offenders.
Yes.
I believe that number is the number of offenders that are out in the community, whether they're on parole or probation or unsupervised. And I think that number includes a number of offenders that are at DOC. That number sounds like the total number of offenders that are actually on Guam. I don't see the 500 here under 2017. I see 500 under level 1, but I don't see 500. I see 500 under our, no, I don't see it anywhere else. So I believe that number is the number of offenders at DOC, plus the number of offenders on parole, plus the number of offenders on probation, and the number of offenders that are unsupervised.
Okay. All right, you're right, because the table in the Bureau of Statistics and Plans is very similar to the table you've provided today, and it shows 308 unsupervised for 2017.
Yes.
So you must be right, that the 543 that the BSP uses in their narrative is a combination of the 308 plus other numbers.
Yes.
Okay. Appreciate that clarification. Thank you. On the website, there's a listing of several convicted sex offenders who are required by law to register but have failed to do so.
Yes.
Can you please explain the process you use? What do you do with those?
Yeah, these individuals have been on there for years, maybe even more than 10 years. We've exhausted all our efforts. The U.S. Marshals have tried to find them. We've contacted the Philippine Embassy. Basically, they're just not, they can't be found. But they've been on there for years. These are the 4 guys that we just could not contact. We got everybody else except for these 4. And so they might not even be on Guam anymore. They might not even be alive anymore. We just don't know. If they do pop up, we'll certainly register them, but there's no knowledge of where their whereabouts.
All right. So did I hear you correctly that you partner with other agencies to help locate these
Yes.
people? All right.
Yes,
And
we
so
do.
you feel like you've exhausted all efforts?
Yes.
All right. Thank you. I'd like to recognize the presence of Senator Pito Terlaje. Thank you, Senator, for being here. He's the chairperson of Public Safety. But I'm going to open it up now for the panel to ask the judiciary questions before we move on to the others in your panel. If Senator Shelton, please.
Sidus Masi, Madam Chair, and thank you all of you for being here today. So first for the judiciary, I understand that Title 9 of GCA, Chapter 89, states that certain information must be provided by the government in the sex offender registry. So those things include treatment documentation, documentation of any treatment that the sex offender has completed, is currently undergoing, or wherein the sex offender has been ordered to attend and complete by any court on Guam as defined under this section 89.01. So in my review of the sex offender registry online, I don't find any of this treatment documentation that's provided. So I'm wondering if those are records that you are keeping and if they should be online or if they're available for review, perhaps if I come into your office.
So they do receive information on treatment on sex offenders, but because of perhaps confidentiality provisions, it's not something that could be made available on the website or to the public.
Okay, but you are keeping the records for yourselves?
Yes.
Okay, just wanted to clarify that. Thank you. Okay, also, the GCA chapter or Title 9 Chapter 89, Section 89.03 states that persons required to register on Guam, the following person shall have the absolute duty to register on Guam at the Judiciary of Guam Probation Division pursuant to this chapter. Residents, any person who resides on Guam that has been or is hereafter convicted of a sex offense, and non-residents, any person who is a non-resident who is on Guam for the purpose of being employed or as a student and has been or is hereafter convicted of a sex offense. So I am wondering about the specific case of Professor Eller from the University of Guam, who is not on the sexual offender registry. If he was convicted of a sex offense, why is he not required at this time to register?
Mr. Ellert's case is still pending decision from the appellate court, and so until there is a conviction rendered or a decision rendered by the Supreme Court of Guam, at that point, there would be a determination of whether or not he'd be a registered sex offender. So
Okay,
it's still pending.
Yes, thank you very much. So if his conviction was stayed by the judge, could a law possibly be written in which, to say that it would still require him to be registered on the sex offender registry during that period?
I think from the judiciary standpoint, there is a process for the justice system, and a defendant is entitled to an immediate right of appeal. We wouldn't take a position to say we support legislation that would immediately require a sex offender upon conviction at the Superior Court by a jury or by a guilty plea that you immediately register as a sex offender. If the legislature intends to do something to that, then you're more than welcome to. But at this point, I don't think we could take a position on whether or not we support that.
Okay, I understand. Thank you. Okay, also, I understand that Professor Eller is currently a teacher at a different university in a different country. Does Guam have a responsibility to inform the other jurisdiction where he is now residing of his sex offender status? Or any sex offender who moves, do you have that responsibility?
If the individual was already registered with our sex offender registry as a resident of Guam, then Mr. Payumo says we do have an obligation, but because he's not registered as of yet.
Okay, so typically if they are already registered, you would inform the next jurisdiction where they would move to that he has moved there?
Yes, absolutely.
Or he or she? Okay. Okay, and that's it for now, maybe more later. Thank you.
If you could just clarify, so information that is not provided on the website that you are keeping, who has access to that? Such as the treatment.
For the probation? Can you just clarify, you're talking about the treatment records?
Yes.
The treatment records, we don't even have access to the actual treatment records. That's confidential, and that's basically with client services.
Yeah, they typically. So if there's any report about treatment, there's only the cover sheet, and no one is privy to what's in the content of the letter regarding treatment. And I'm assuming, maybe not, some of the folks are also privately treated. And if it's a private treatment, with a private provider, obviously those are also confidential.
All right. This seems to be another case of where the statutes may contradict almost, because it's mandated in the offender registry statute that information will be available by, it says provided by Guam. And that you're saying it's confidential by maybe another statute again. Yeah, I think we need to resolve those two.
I believe the only document we have in our file that has anything to do with the treatment with client services is the completion letter. But the actual treatment process, that's confidential.
All right, it's supposed to be, has completed, is currently undergoing, or ordered to attend. Okay,
Yeah.
that's supposed to be made available also. All right, if I may also recognize the presence of Senators Kelly Marsh Taitano, thank you for being here, and Senator Sabina Perez, thank you for being here. All right, so we have just heard. We've just heard from the judiciary of Guam on the far left of this panel are the members from the judiciary. And okay, please proceed, Senator Shelton.
I'm sorry, Mr. Palomo, can you just repeat what you said? What is the record that you do keep?
We keep the completion letter. If they go through treatment with client services,
Okay.
we don't get to see the actual information regarding treatment, but we do get the letter stating that he has completed, and we report that to the court.
Okay, thank
Yes.
you.
You're welcome.
All right, Senator Moylan, did you have any questions for the judiciary?
Thank you, Madam Chairman. Mr. Palomo, for those that,
Mr. Payumo?
Mr. Payumo, sorry. Sorry, buddy. So you're busy out there, you're looking for these guys, making sure that where their residence is as specified in on the website, right? So you find out they're not there, so you get them and they update you on their residence, right? Phone number, residence. Is there any repercussion for them for not telling you in advance before you find out, right? They're supposed to notify you, right, or the probation office, but if they don't, then you end up finding out and looking for them, and then you update it. But is there any punishment that they receive for not updating you properly?
Yes, they could actually be charged with a felony, a new case, if they report false information to us, or if they don't come in and report that they've moved to another residence. But what we're finding out is if we go to a residence and the offender doesn't live there anymore, we'll do our investigation, and if we can find out where he's at and get him to come in and report that new information, that's the process right now. Now, if we can't locate that individual and get that updated address, then that's when a letter is drafted that's sent to the AG's office, and that's when the process starts for a new case to be charged out against that offender.
Have you had cases where you had to take it that far?
Yes, as a matter of fact, I looked that up before I came down today. Starting in 2012, we sent 3 letters to the AG's office. In 2013, it was 4. In 2014, it was 5. 2015, 5. 2016, 2. 2017, 5. 2018, 4. And 2019, so far, there's 4 letters that have been sent to the AG's office.
I'm just wondering, since you're so busy, and if they can't report themselves properly, that they change their addresses, and it's costing you time, your division time, does the law need to be stringent on them? Do we need to do something to make that a greater penalty for them, or just violation of parole right offhand? If they can't comply with the basic requirements of telling everybody where they're supposed to live. Basically, they're lying and trying to get away with it until they get caught.
Yeah, I'm not sure. I just know that this is the way the process works now. And
Yeah. So the felony offense would have carried. Has there been any prosecution for that, where they changed their address and you report it to the AG, you can't find them? Has there been any prosecution for that?
Oh, yes, actually, okay. So in 2012, of the 3 cases that were reported to the AG's office, all 3 were prosecuted. In 2013, out of the 4 cases reported, all 4 of them were prosecuted. In 2015, out of the 5 cases reported, 3 of them were prosecuted. I think the other 2 were deported, so they didn't go through the prosecution. 2016, the 2 cases that were sent to the AG's office, 1 was prosecuted. And then in 2017 and 18, so far, those cases are still pending with the AG's office.
Okay. Thank you so much. Thank you.
Thank you. Senator Pito Terlaje? Okay. All right, if senators, we'll proceed with, or did you want to ask the judiciary? All right, we're going to proceed with other. Chief Kanata, would you like to add anything to this discussion specifically on the offender registry and monitoring of those who are released? I know I asked, you're the chief parole officer, if you could describe for us you're monitoring while on parole for those.
Okay, what has come as a result of what's been going on is
I'm
the
sorry,
board.
yeah,
The
can you
board.
make it louder? Yeah.
Good afternoon. As a result of what's been happening in the last few months, the board has, we spoke with the board, myself and the board, that starting next month, we're going to start requiring the sex offenders with juvenile victims to be reporting weekly. That's just like self-reporting. And then from there, individual cases to determine later on, should the weekly reporting be necessary. So we're working on that, and also the board ordered that no case will go in for violent crimes without a psych eval. You just will not entertain any of those cases. That's the only thing you can report from the parole site. And with working with probation, we started the system years ago, and we have that good rapport. So, you know, if they're concerned about a certain person on the registry, if they're on parole, they'll call us. And we have a good working relationship with that. Like Ruben said, sometimes we'll go out with them to the field to check residents.
What are the cases that cause concern? You've used that several times. Which cases cause concern that would cause you to do increased monitoring, as you described it?
Well, as a result of what's been happening, the board decided that since these guys are only required to report once a month, the board is ordering that any criminal sexual conduct case where the victim is a minor, they're going to be required to be reporting once a week.
Do you verify the information on the registry, such as house location, employment, and school, those locations that they are attending?
Oh yeah, each officer behooves them to do that, to be cross-checking if there's any changes, and checking with Ruben if they're seeing Ruben and making those changes on their own. If not, then of course we'll alert Ruben.
If not, then what?
We'll alert the registry, Ruben.
Okay.
Yes.
All right. Senator Shelton?
Thank you very much. Chief, during the last roundtable, we discussed the CBI therapy that was optional for those convicted of criminal sexual conduct. I'm wondering, can it be a condition of parole to complete that therapy before they come before you, or they're eligible?
It could be a condition. I will bring that before the board. They're the ones
Okay.
that will order it.
Okay, so just
Yeah,
Masi.
Just before we move any further, want to verify then that at your stage, at the offender registry stage, there is no additional assessment that's being done as to risk of those people who are on the registry. Is that correct?
Actually, there is an additional risk assessment that's done on our clients, and when I say our clients, I mean the probation clients.
Oh,
We
okay.
don't have any authority to do risk assessments on the quote-unquote unsupervised registrants that are off community supervision. So we have done risk assessments on our probation clients that are under our supervision.
And what is being ascertained in that assessment? What's the goal? Is that, in the last roundtable, they said that the goal of the probation's assessment, the ORAS, was it? Was just to determine whether they were going to show up for their next hearing. Dr. Rapadas?
Yeah. No, it sounds like that, so for example, sex offenders specifically, if they fall under the supervision of probation, they don't get a sex offender assessment tool. They'll probably get the ORAS. Another thing that we're trying to use, a lot for the drug offenses, is what they call SCL 90, which is another tool. It's 90 items of symptoms, and if they pop positive on depression or anxiety and stuff. So, but I don't, as far as I know, they're not, probation's not giving any sex offender tool, but general stuff like ORAS or the SCL 90.
And is it also clear that those who are under the category of unsupervised, meaning they're not on parole or on probation any longer, they're released, they're on this registry, but they're not required to undergo any type of treatment at that point. Is that correct?
Yes, that's correct. Their monitoring is based on their actual level, 1, 2, or 3,
All right.
and 1 being the highest.
The reporting?
Yes.
Okay.
Yeah.
All right. We had also we had talked a lot about this assessment tools, right, that were available, and at every level, pre-sentencing, sentencing, and then of course post-sentence, and even during the duration of their incarceration, Dr. Rapadas had recommended that assessment should be done throughout these periods. So we found that there was no specific assessment being used for criminal sexual offenders, measuring their risk of reoffending. We've asked the judiciary to provide their best recommendation for a risk assessment for these offenders, and so we're hoping to receive that when it is available. And we want to pursue whether a tool like that can be used successfully by, across the board by everybody involved in the system, including the Department of Corrections, the parole, and so we know the risk on release. So I guess that's what's driving this for me, at least, is we know that these people are being released. We know that they have a history of sex offense. We want to know what the risk is to the community in their release, and if there is anything more that we can be doing to decrease that risk to the community. For example, monitoring more, or treating more, or more notice, which is why I think I'd like to move on, if it's okay with the senators, to the others on the panel, if they'd like to add anything to this discussion. Mr. Attore, is there anything? Stephen Attore from the Public Defender.
Thank you, Senator. And I totally agree. I mean, if we wait for them to be eligible for parole to make that assessment, it's too late. Because at that point, what can you do for them if they're, like they've already met 85% of their sentence, and they're just going to be denied release because they haven't been given the opportunity. So clearly, it's going to have to happen at the court side, whether it's after a change of plea, before sentencing, whether it's a condition of a sentence that's imposed by the court. And so once you do it at the front end, then you could pretty much draw a roadmap for the treatment that they need. And otherwise, it's just too late.
I'm glad that you concur. I concur with you on that. All right. So welcome, Monique, Baza, and Karina, whoever. Would you like to go first, Karina? If there's something you'd like to add?
I go first? Hafide, and thank you. My name is Karina Farron. I'm the president of the Guam Family Justice Center Alliance. I did write a testimony, and I would like to read it. At the roundtable discussion a couple of weeks ago, I watched a variety of government of Guam agencies lack in their knowledge of the protocols and procedures regarding sex offenders leading up to their parole hearing. All but the Judiciary of Guam had statistics on data, highly necessarily in formulating Guam's current state of sexual assault. All forms of government, judicial, legislative, and administrative, have failed many victims for years, and Guam's people have reached a point where enough is enough. Are we forgetting the federal victim rights laws? These are the crime victims' rights according to the United States Code 3771, that our laws should work in sync and in accordance with these laws. These laws were written to protect the victim, and every state and U.S. territory need to be well-versed in these laws. Our government agencies are not doing their job in keeping both the community and victims safe. More than 75% of our victims are children. As I read through it, many of our government agencies have failed victims time and time again, and yet we are releasing pedophiles only to hurt more victims. According to the crime victim's right, a crime victim has the following rights. Number one, quote, the right to be reasonably protected from the accused. Our government failed to protect many victims' mental, emotional, and physical safety in addition to harassment and abuse time and time again. and is evident from the parole board's review as they knowingly let perpetrators out on parole, that there has been no psych evaluations prior to them exiting, as well as knowing that those who are pedophiles will revert back to their old ways. In addition, our Attorney General's office and our courts have failed to fight effectively on behalf of these codes by allowing softer sentencing for serious perpetrators who are given little to no jail time. The Attorney General's office and our courts over the years have failed on several occasions to serve in accordance to this bill, number 5, which is Bill Victims' Rights Bill number 5, code stating, quote, "A victim may make a motion to reopen a plea or sentence only if A, the victim has asserted the right to be heard before or during the proceeding at issue and such right was denied. B, the victim petitions the Court of Appeals for a writ of mandamus." And that is an order from a court to an inferior government official ordering the government official to properly fulfill their official duties or correct an abuse of discretion according to the, and this is according to the Cornell Law Dictionary. And that's within 10 days. And in the case of a plea, the accused has not pled to the highest offense charge, end quote. In the case of writ of mandamus, the Cornell Law Dictionary also states, quote, "Mandamus is an extraordinary remedy which should only be used in exceptional circumstances of peculiar emergencies or of public importance." Are victims and our community of public importance? Definitely. A couple of examples where victims were not mentioned about their perpetrator, or perpetrators got more of an advantage. Take Mark Tysopik, who pleads guilty to child sex abuse and gets no prison time. Professor Eller, his victims were given only 2 days notification. Glenn Siguenza Santos was guilty of sexually assaulting a teen, released until sentencing. And so here they are, just walking free. So I ask, are we really thinking about the victims? Next, the Victim Bill of Rights states the right to reasonable, accurate, and timely notice of any public court proceeding or any parole proceeding involving the crime of any release or escape of the accused, end quote. Many victims did not receive notice their perpetrator was out for parole, was released on bail, was let out on good behavior, or was not aware that court proceedings were taking place and were not read the Victim Bill of Rights to know that they have a right to these codes. And these are victims telling us, these are the survivors telling us. Quote, number 3 of the Victim Bill of Rights, to not be excluded from any such public court proceeding unless the court, after receiving clear and convincing evidence, determines that the testimony by the victim would be materially altered if the victim heard other testimony at the proceeding, end quote. Victims need to know. They need to know every step of the way regarding the court proceedings and the importance as to why they need to be heard. Many victims are not given this option, and at times they feel those who are representing them are rushing or lack knowledge regarding their case. Number 4 of the Victim Bill of Rights, the right to be reasonably heard at any public proceeding in the district court involving release, plea, sentencing, or any parole proceeding. For additional due diligence and to make sure this law is being used, both the parole board and the AG's office must make it mandatory to inform the victim in a reasonable amount of time. Standard operating procedures must be followed, and all those who are getting paid to serve the public and protect the community need to be held accountable. When laws are not followed and the best interest of the victim and the community is not being upheld, let's stop putting the perpetrator first. Let's put the victim first. Number 5, the reasonable right to confer with the attorney for the government in this case. Number 6 of the Victim Bill of Rights is the right to full and timely restitution as provided by law. Number 7, the right to proceedings free from unreasonable delay, end quote. How many times have we seen on the news and heard from victims that courts have excused perpetrators for reasons such as the defendant wasn't feeling well today, the defendant's lawyer was not prepared, or victims were never given a reason as to why there was a delay. And number 8 of the Victim Bill of Rights, it says, the right to be treated with fairness and respect for victims' dignity and privacy, end quote. Then on C, best efforts to accord rights of these codes, it says, quote, government, officers and employees of the Department of Justice and other departments and agencies of the United States engaged in the detection, investigation, or prosecution of crime shall make their best effort. It doesn't say little effort. It doesn't say no effort. It says shall make their best effort to see that crime victims are notified of and accorded the rights described in subsection A, which is the Victim Bill of Rights. It is your best effort. Is it your best effort to pass the buck or pass the blame? I mean, that's what we've seen at the roundtable discussion. We also hear that they're not paid enough or it's difficult to carry it out. So much is to be blamed on our government risking our communities' lives. Do we not have a sense of urgency or proper ethics to carry out the job that we hold, the job that is meant to be as a public servant? Then on D of the Victim Bill of Rights, enforcements and limitations, it reads, quote, a person accused of the crime may not obtain any form of relief under this chapter. And yet you see so many times where the perpetrator gets relief. We must all know these laws should be mandatory and necessary to know in every agency. And I was very surprised that many people in public service do not even know that these laws are mandatory and that our laws should work in sync with this. Finally, on F, procedures to promote compliance of these codes, it reads, a designated and administrative authority within the Department of Justice to receive and investigation complaints relating to the provisions of violations of the rights of crime victims. B, it says require a course of training for employees of the Department of Justice that fail to comply with provisions of federal law pertaining to the treatment of crime victims, and otherwise assist such employees and offices in responding more effectively to the needs of crime victims. And C, it says contain disciplinary sanctions, including suspensions or termination from employment for employees of the Department of Justice who willfully or wantonly fail to comply with the provisions of federal law pertaining to the treatment of crime victims. There is so much more. And if you have not read on it, please do so, senators. After hearing the Victim Bill of Rights, and there's so much more to it, when it comes to risk assessment, is it possible to believe that those who are supposed to uphold the law or keep our victims safe, are they doing their job? And that's a serious question to ask. Senators, let's draft legislation on behalf of the victims and safety of our community, not on behalf of the perpetrator. I urge you to really, really consider this, because where it's going now on Guam, I'm from here, and pretty soon I don't want to be here anymore.
Thank you, Karina.
Good afternoon, Senators. I also wrote testimony. My name is Monique Baza. I'm the Vice President of the Guam Family Justice Center Alliance. How many of you were aware that there is a man who is a level 1 sex offender whose victims were 2 11-year-old female minors that roams the streets of Hagåtña on a daily basis in plain view, where for many hours of the day can be seen convening with other individuals outside of public places like the library, Paseo, and the Hagåtña Shopping Center, all locations where school-aged children are located before and after school hours. The very thought that he has so much access to children who are around the same age as his victims is very unnerving and unsettling, and this is a perfect example why public notification of individuals on the sex offender registry is important. But the public has a right to know outside of the sex offender registry website who is residing within their communities. Yet Guam solely relies only on this form of notification, and even at that, if you go onto the website today, you will see in big, bold, red letters several convicted sex offenders who are required by law to register personal information and periodically update that information for inclusion on this website have failed to do so. Sorry. The list below identifies the individuals who are not currently in compliance with their statutory reporting requirements. If you know the whereabouts of any of these non-compliant convicted sex offenders below, please contact the Judiciary of Guam Sex Offender Registry, and the number is provided. The thing that really upsets me is the last sentence. How are we as a community supposed to know that these individuals are non-compliant if we don't regularly see these notifications outside of this website? And the other thing is, many people do not have access to the internet to even see this list to begin with. When I was growing up, I would see posters of missing children and of the FBI's most wanted at village post offices. People would stand and read these posters while waiting to get their mail because what else was there to do in line? Sometimes, if you were observant, you could see these at local mom and pop stores. And while posters and signs are a very simple yet effective approach to notification, you don't even see anything of the sort today. I emailed the Office of Sex Offender Sentencing, Monitoring, Apprehending, Registering, and Tracking, also known as SMART, which is the federal office responsible for assisting with implementation of the Sex Offender Registration and Notification Act, just to inquire if publication is only limited to the website. And their response to me was that publication of registration notification is determined by states and counties. In some jurisdictions in the United States, offenders are required to put a sign outside of their residence informing their neighbors the level of offender that they are. This is especially important for offenders who are repeat level 1 and 2 offenders. So I ask myself, is Guam taking a very minimalistic approach to notification with regards to sex offenders once released into the community? Now, it is of no surprise to the people of Guam that the government is in a financial crisis, or that agencies within the government do not communicate with each other as they should, as displayed in the public hearing regarding parole board procedures a few weeks ago. But when it comes to public safety, we as a community and as an island should expect that safety is at the forefront of everyone's agenda, and that agencies are working diligently with each other instead of passing the buck or thinking it's another agency's responsibility to address. But I am pretty sure that within this body and its network, that we have the means to work with local businesses and community organizations to develop creative ways to help spread awareness. And as a start, our organization has published the Sex Offender Registry link on all our social media platforms on Facebook and Instagram. And this took all but 5 seconds. Another creative way you can help notify the public of the Sex Offender Registry is to work with these multimedia advertising boards to have a regular rotation of individuals on the sex offender list, most especially those who are not in compliant and those that are level 1 and 2 offenders. Guam receives thousands of dollars in federal grant monies that can help support this effort, such as the Project Safe Neighborhoods grant that was roughly about $68,000 and was awarded last year. The aim of this grant is to combat violent crimes and make the community safer through a comprehensive approach to public safety that marries targeted enforcement efforts with community engagement, prevention, and reentry efforts. And if you ask me, some of this funding could have been used to pay for such multimedia ads or for the production of informational posters of the Sex Offender Registry. And what about PSAs? I know that the local television stations have room in their scheduling for PSAs, and movie theaters can also play these prior to matinees. And as a matter of fact, I have worked with the GCC VisCom class on several PSA campaigns to target sexual assault that have been played in these theaters. So I know these messages would reach thousands on a regular basis. Knowledge is power, ladies and gentlemen, and with all the money that Guam receives to combat violence within the community, it is a shame that more is not done to empower its people so that we can do what we can to protect ourselves. And finally, I just had a couple of questions that I would like more clarification on. What is the process or criteria that sex offenders have to meet in order to satisfy release conditions besides registering on the website? Number 2, is there a checklist that must be signed off by certain agencies so that the individual has processed through their office and has been oriented on the expectations set by these offices, such as parole and probation? A checklist is a perfect way to help agencies get on the same page. If the checklist cannot be completed by a certain time period, the offender can be picked up for violating release conditions. Number 3, which was answered by Chief Kinata, who monitors these individuals once they are released into the community, and how often is this accomplished? You indicated moving monthly to weekly. Thank you, sir. Number 4, are sex offenders required to register with their village mayors so that the mayors know where they are residing within the village? And if they are pedophiles, are they given strict conditions that they are not to be within a certain distance of children, such as in school zones? Because if this is so, and they are registered with the mayor's office, then the mayor's office would be able to reach out to the courts to inform them of the possible violation. This is all I have for today. Thank you for hearing me.
Thank you very much, Monique. Thank you for representing your organization, but also thank you both for being here personally. It means a lot that you take the time to do this and to advocate for all victims of Guam. I think there's one idea that we talked about that you didn't include on your list, if I may add it. It was, in addition to registering with the mayors, it was to go further and also to inform schools in the area where these people resided, so that they also were aware of who might be in the area.
Yes, ma'am.
All right. Is there anyone on the panel who would like to add anything after that testimony? Otherwise, I'm going to open it up to the senators for questions.
Just as a follow-up to what Monique mentioned about more awareness and outreach, I will share with you that the judiciary currently partners with the Department of Education, perhaps over the last 10 years, on law-related education programs. And I can tell you that in the last 10 years or so, especially since the law changed on sex crimes, as part of our outreach, myself and 2 other certified trainers at the judiciary, when we go out and meet with kids to teach them about cyberbullying, bullying, sexting, and criminal sexual conduct, we actually show them how to get to the sex offender registry, how to look up someone within their village, someone within their school. So we try to take proactive measures, and annually we try to reach thousands of students in the middle and high schools to tell them that, you know, it's a serious offense, and if you see this person, so we tell them, you know, they're also tech savvy. Look at your phone, take it out, go to guamcourts.org, and here's how you can find out. And they, you know, to their surprise, they get shocked by it, but we show them the process and how to access it and get to that link.
I don't want to overlook that. Could you repeat for everyone who's listening how to access the criminal sexual offender registry for Guam?
On the judiciary's website, www.guamcourts.org, that's the main page, and when you get onto the main page, there should be a link or a tab that says Sex Offender Registry.
All right, and on the registry are pictures available?
Correct, yes.
Thank you. All right, questions? Senator Pito Terlaje?
First off, I just want to thank the panel for sharing this wonderful moment with all of us. But I just wanted to get a hold of the statement that you put out, because you had mentioned that the Attorney General's office and the court is not doing as much to remediate the problem that we're facing. And I would like to a copy of that statement, and even the other previous speaker. I would like to have a copy of that statement also, so I can base myself on just what we need to do to kind of just evaluate the statements, and maybe we can do something to straighten the problems that we have. Thank you very much.
Senator Moylan?
Thank you, Madam Chair. On 89, subsection 8913, the electronic monitoring of sex offenders, for the court and for corrections, it says the court may order the sex offender to wear the electronic monitoring device. And for parole, it says the territorial parole board may require to wear the monitoring devices. With the lack of some of the compliances of finding where these sex offenders are, they don't keep up with the registry, or if in cases where we've had the offender commit another crime, instead of may, if it was shall wear these devices, would that have been helpful for either the court side or for parole side, that they must wear the electronic devices instead of may? So in other words, the court is saying, okay, we could do it, but if the law says you shall do it, and the parole board is saying, we could order it, or we say the parole board shall order it. Would have been helpful for you on your side to help find and continue monitoring or do some preventive measures?
For the parole side, it will be a funding issue. Now the proposal about having them pay for it, that could be another option. And they just won't be out because a lot of them won't afford it. That's
Other than payment, would that help you?
Of course.
How so? How so, please?
Just if we're monitoring the, whatever sites are not supposed to be, with technology now you can actually track them. So, I'm pretty sure that would help in monitoring these guys, yes.
Thank you. On the court side, anything?
I think on the judiciary side, as you are aware, we have been funded for electronic monitoring for pretrial detainees, those that have not been convicted of an offense. We are in the process, as our Chief Justice mentioned, we are in the process of making a selection to a vendor, and sometime this summer, it is anticipated that we will consider the use of electronic monitoring for pretrial defendants. But if there's, obviously if the language is mandatory, then, and as the Chief mentioned, it's a funding issue. We'd have to find the funding for it, and perhaps it could be a tool for those that are on probation that have a sex conviction. Because the law changed, and it's mandatory minimum 15 years for the most serious offenders. The ones that are typically on probation now are fourth degree criminal sexual conduct offenders. So the level and the severity of the offense, once they're sentenced, ideally is that they're serving an immediate sentence at DOC for the serious offenders. And so for the parole board, it would be before they're released on parole, perhaps could electronic monitoring help them in their supervision.
But these folks here on the register, right, they're CSC offenders, right? They're not, some of them don't show up. That's why we have this listing of where do they live and everything, what you were mentioning, right? Besides the money fact, wouldn't it have been helpful if we had a monitoring devices on these guys' ankles and we don't have to worry about where they live now because we can track them? Wouldn't that be helpful?
So you're saying, to clarify, you're saying those that are registered on the sex offender registry, whether they're supervised or not, the fact that they're on the registry, is it helpful for them to be on electronic monitoring? So perhaps Ruben didn't have to do his 400 checks to see if you're really staying where you are staying. Is that what you're asking?
That's correct. And for those that don't show up and they're missing, wondering where they're at, if they had this thing on their ankle, wouldn't that expedite your process?
Yes, absolutely, that would be helpful, but it's my understanding that we're only talking about putting ankle bracelets on people under community supervision. The majority of these guys that are absconders, the 14 that are currently on the front website, they were under the unsupervised category, so I'm not sure that we can be placing electronic monitors on them if they've completed their community supervision. I might be wrong, but that's my understanding.
Okay, thank you. Just one more, Chief. Do we have any from off-island that were under parole for CSC?
If they do get permission to leave off island and they have our CSC, one of the conditions, they have to report to that state and register. And if they don't, it becomes a federal offense anyway, so it's always going to be following them.
I was just wondering, how about those coming to Guam that are CSC?
There's only one that we have that's on Guam that's been on the system for 20 years. I believe they're going to discharge him, at least from his state, but he's still, if it's a lifetime registry, he still has to report, but he won't be supervised by us.
Okay, thank you. Thank you, Madam Chair.
If I apologize, I wanted to add this earlier, if I may just add it right now. We did receive, after the last roundtable, a report from the Department of Corrections pursuant to what we had asked. And so this report details, it's a list of every person who is incarcerated for a criminal sexual conduct offense. It lists their conviction date, their parole date, their full-time release date, which are all in the future. So this is for, I wanted to know if there was another way the community could know these and help monitor or do the ideas as Monique Baza had stated. It's a community information effort. So they did provide this list, and so we know that there are some who will be coming up for parole, and of course we know there are some that will continuously be coming up for release pursuant to their sentences. And it's the sentences that set whether they're on probation. The sentence dictates whether they may be considered for parole or not. It determines the date of their release. And so I just wanted to go back to the point that he was talking. So there's, on the judiciary also provided us a very concise report. And so the ones we're talking about here, we've got people under parole. So we want, of course, to shore up whatever it takes for you to monitor them, but those we call monitored, right? Because they're under parole and you parole officers are monitoring them. We have some criminal sexual conduct offenders who are under probation, and they are what we also deem monitored. So they're also being monitored in the whatever way probation dictates. And in those cases where they are monitored, there may be conditions as to where they may be. So in those cases, perhaps this electronic monitoring device may be helpful to let you know whether they're in the place they're supposed to be or another place. But for this other category of unsupervised, pretty much that means they've been released and they're no longer under parole. They're released, and we don't have any other restrictions on them as to where they may or may not go. Is that correct? For criminal sexual conduct offenses?
Just their requirement to register.
Okay, so they're only required to
their,
register.
information update.
Okay, great. So that's the issue that I'm trying to, focus on. So those who are unsupervised, there's no restriction on really where they can go. In fact, so they're supposed to be registering and reporting for themselves, self-reporting their home address, employment status, where they work, where they go to school, their driver's license, and their vehicle. And it's my assumption that's for two purposes. That's, of course, for monitoring, so we know where they are, and if somebody wants, somebody's kidnapped and they want to look for this person, they know where to find them. But it's also for that other prong, the very important prong of, it's for the public. This registry is for the public to know, as the two of you stated, who's in your neighborhood, who's near your village store, who's near your village school, who's attending activities where your kids are attending. It's that type of information. It's a huge burden, I think, on the public to decipher all of this, as you've pointed out, from a website and translate that into our daily lives. That's a huge burden. And so I very much appreciate your testimony as to how perhaps the government and how they have done it in different states. The government has helped in that regard by requiring a little bit more information to the community. Signs, like you've said, publishing them on those screens is a great idea. Other ways, and that's just for the benefit of the public, for us to pretty much help ourselves to protect our children and when we realize what we learned at the last roundtable, that there are many who are being released, some who may be high risk. We don't know for sure, we have no gauge, but of course we know there are some that may be high risk of reoffending, and we know that they are also, for the duration of their imprisonment, were not treated in really any way, and are not being monitored by anyone else except for self-reporting that little bit of information. All right. So thank you for that. So I do have this information from the Department of Corrections that I will provide to my colleagues, and it also talks about repeat offenders, and they gave me data from 2015 to the present. Yeah, January 2015 to the present, which talks about how many repeat CSC offenders they had, whether they were under parole or not, and that type of information. So I will also provide that to you and to the panel up here. And so Senator Shelton.
Thank you again, Madam Chair, and I want to thank Corinne and Monique for your testimony today, especially the suggestions that you provided. I think those are very helpful to us, especially as we continue to draft policy to address some of these problems that we're facing as a community. Mr. Payumo, I have a follow-up question for you. I know that you mentioned that you make about 4 visits per year to these people on the registry. Is that correct?
We work with the U.S. Marshals and get out into the community 4 times a year and try and do as many it takes a week. So we try to do as many in 1 week that we possibly can, 4 times a year, yes.
Okay, and do you think 4 times a year is enough? Is that what typically is done in other jurisdictions, or do you think that we can do better in that checkup?
We can do better.
Okay.
I don't think it's enough.
Okay. Have you ever partnered with other agencies, such as the police department, to help you to do these checks?
Yes, we work with all the law enforcement agencies on Guam, parole, GPD, even customs have come out and help us. The ICE officers come out and help us, the local marshals. So we're in contact with everybody, and they're aware of what we're doing, and they help us when needed.
Okay, so what do you think it would take to increase this number of check-ins? From 4 times a year to whatever the number it is that we need?
Well, of course, we're talking about more officers, maybe because I'm just one officer in the office, and there's a lot of other things that I'm responsible for. And then there might be a funding issue, but certainly it would be better for the community if we were out there as much as we possibly can.
What do you think would be a good number of times per year?
Doing this operation with the U.S. Marshals? Once a month would be nice.
Okay. Okay, thank you.
Yeah.
Senator Kelly Marsh Tyson.
Hafiday, it's, as everybody has been talking about, it's important that we are coming back and revisiting this and seeing what progress we can be making, because as is important and as you two outlined, like, it just has to be done. It's not enough, and I know that there are many that are working hard towards it, but we have to find solutions. So while some of the discussion was going on, I went to the sex offender registry, and I find it problematic, and perhaps there's something there that I'm not accessing, and so you can let me know if I'm not accessing something. But there was the listing of those who have not reported and the listing of those who have not updated. But everybody else, as far as I can make out, is you search for them. You search for them by the level of the offense, by their last name, by their village, by their zip code, at Department of Parks, at the Department of Corrections, and so forth. And so it seemed to me that if there isn't a comprehensive listing where people can run through it the beginning to the end, that's very problematic. So am I missing that? Is that truly the two different ways to access it? The registry, is there any comprehensive listing of everybody A through Z?
I think on the website you can search by level, of course, all the level 1s, and it'll show a list of all the level 1s, or level 2s, or level 3s. You can type in their last name if you're aware of it. You can also type in the village, which will show you all the offenders that reside in that particular village. I think there's also a zip code option there. You can type in the zip code. And then it shows you a list of all the ones at DOC. I think those are all the options that we have right now.
Right, so, and then at the Department of Corrections and off island. So it seems important to me that we need to have that listing from A to Z with the photos, with understanding their offenses, because as they pointed out, they may live in pick a village, but they're in Hagatnya. So if I'm from another village, like I don't know, and I'm not going to sit here and search them village by village to go through all 19 municipalities to understand them. So I think it's incredibly important to be able to just see it from beginning to end, so that parents, neighbors, whoever it is, that they can just look at it and feel like they've understood some names. They could print it out. They have visual recognition, like something. So I think that would be really important. And if I'm reading this table correctly, is it saying that we're supposed to have 890 registered offenders on the website? Is that what this? Yeah, so, that's another part of it. Because we can't see it comprehensively, and I can see 9 at a time, it gives no real sense of where we are in the pervasiveness, here. There's a huge difference between putting in a village and getting 0, putting in a village and getting 9, and understanding that there are supposed to be 890 that are registered. So, again, I think for it to be a tool that continues to serve the public and our residents.
So to add to that, Senator, we do manage our website internally at the judiciary, and I think what Mr. Payuma and I will discuss is going back to see, and obviously looking at other sex offender registries. We probably modeled this after a registry in some other court jurisdiction or some other state, maybe to make it more user-friendly. Maybe if you just clicked on, what is a level 1 sex offender, right? So I think internally we can look at that to see that from the public's perspective, how could we make the navigation more seamless and user-friendly
Right, well, informative of incredibly important information. And I know you all take your job seriously, so I'm not trying to imply that you don't, but this topic is so difficult. I have grandchildren that are of the age that they tend to start being victimized. I don't know your situations, but I've been victimized in the past, which is partly why it's so emotional for me. And there's just no overstating the importance of protection. And again, I know you guys take this seriously, but it's something you never get over. It's something that impacts you forever. And so, if it's something as simple as making it more comprehensive, then definitely we need to do it. And we need to find the funding to give you guys the tools so that you can actually do what you want to do. We just have to do those things. But in some of the other things that I wanted you guys to help me understand. So as I read it and I go through these charged offenses, and I look at 2016 to 2017 and 18 and 19. So it looks to me like we're having increasing issues in one way or the other with those that are victimizing those that are under the age of 14. That those offenses, I don't know if the number of individuals is more, but the number of offenses. So I don't know how to read that as to whether we are having more individuals being charged or whether it's a certain number of individuals, but they've had multiple charges per person.
So the data that was provided this afternoon on the charged offenses, as we regularly report in our annual report, starting with 2019 all the way to as far back as 2016, this will show you the number of offenses that the Attorney General's office charged with respect to any form of criminal sexual conduct under the law. Now, this is, in many cases, there's usually more than one criminal sexual conduct offense per case, which was why, if you look at the number of cases, for example, in 2018, we had 79 criminal felony cases that involved a criminal sexual conduct offense, but in 2018, we had 357 or 290 felony offenses. So you take the 290 and look at those 79 cases, and that's how those offenses were kind of included in those cases. And those are cases where the magistrate's complaint or the indictment charged out that offense under the statute. And we see that in 2018, second degree CSC for minors less than 14, we had 108 of those offenses charged.
Now, one of the things we had talked about at the round table, and so it seems to me, but again, maybe you can walk me through some of that, it seems to me it doesn't match up with what I was expecting based on that round table, that they were saying most offenses aren't for victims under 14, and that most that go through treatment or other things, or they're not repeat offenders, and that it's those who victimize minors that are the most problematic. So it seems to, I mean, in looking at this, the numbers are showing, at least for the number of offenses, those seem to be pretty high. And so I just feel like we definitely have an issue. And I'm not sure, based on what we had talked about at the last roundtable, if we even really understand how often this is not reported and how often it's actually occurring. Are there any studies that provide you guys the tools to understand how often it's not being reported and how prevalent it is?
Not at the judiciary. We just have jurisdiction to handle matters that are filed cases when brought by the Attorney General's office. And again, the number of offenses charged, that's at the discretion of the prosecutor. So you'll show in one of the tables I provided, there was, based on the same time period, not necessarily the same cases that I highlight for the given years, although there were these offenses charged at the time of adjudication or disposition of the case, not all those offenses stick. I mean, they don't all result in a guilty conviction.
Right. And so I need to do research, I suppose, about whether those studies have been done about our community specifically, and if not, or if they need to be updated to make sure that we're having those done. It gives you information, it gives all of us information, it helps us all understand how to best protect our community, ourselves, and our children. So with sex offenders on island, do you have an understanding about our rate? I guess that would have to be tied to a study. Our rate of offenses for our population, with that ratio, do we rate above or below the national average?
I think it's pretty hard to say. Are you speaking with respect to recidivism, or?
Well, I said to the offenses that are occurring. So if we're reporting them here by year,
So you're saying in comparison to other state jurisdictions, where do we match up or fall under for sex offenses?
for those that at least make it to the system.
I don't have that information readily available, but I could, I do have access to other data from other court jurisdictions, so maybe I could look into that just to see if I can give you
I
some
just feel
feedback
like
on
that would be important to understand.
I
So-
think though, there was some information about the most frequent crimes, and then it goes with the frequency. So it's my sense that I believe the sex offenders are like the 8th most frequent, or don't you have like
Well, we provided the
Yeah.
percentage of our criminal docket for sex crimes, and as I mentioned, like in 2018, 7% of our criminal case filings involved sex offenses.
Yeah, so it's in the data. I think the question would be nationwide, do they also have that same, like nationwide, is it 2%? Then we have a big problem if it's 7%, something like that. We'd have to find that out.
Right, and I think that study, whether it's been done or whether it needs to be updated to help us understand what we're dealing with.
Yeah. Because the vast majority, I think most of us would probably see that it's violence and also drugs. So violence and drugs make up the majority of, now obviously sex offenders is a sexual violence, it's called sexual violence. But it's, from my experience, there's just a lot more family violence and drug offenses, burglaries and thefts. That's why it may seem small if we're thinking, oh, it's such a big problem. It is a big problem. One victim is big to have a big problem, but 7% still, if you have a large amount of crime, 7% is pretty big. And we all don't even want to see one crime, sex offender.
Right, and that understanding for 890, which seems like an incredible number given the size of our population now. Granted, some of the offenders have been on there since at least the 1960s. So it's been accrued over time, if I was reading that correctly, that they've been on there since the 1960s. But it just seems, I don't know, I think a lot of people in our community would be shocked to know that we have 890 that are registered, and then that's not everybody. We know that that's not everybody.
Senator, if I may add, I think the Coalition Against Sexual Assault and Family Violence also has some information, because I remember doing this during the resolution presentations. And for example, in 2017, Guam had the second highest number of rapes per capita, according to their data. And so I know that they also had number of assaults against women in general, I think. So we can probably get that information also from those other different sources, comparison information.
So, Sujus Masi for sharing that, Madam Chair. And so I think it just circles back to the whole thing of this seems like it's an incredibly large issue. We need to do what we can to provide you the tools to make sure those studies are done and to be taking care of this. So as far as doing something immediately, I think what you were saying that you have the potential to do with the website, I think that could be really important. So I think that would be a first good step in helping us all feel like we have a few more tools at hand. Sujus Masi.
Let me just add one more thing, is that it is kind of like a given, even from the Association of Treatment for Sex Offenders. It's a big organization, ATSA. Even they say that there's so much underreporting, you can't even estimate it. So, and I'm assuming Guam is the same. There's probably so much more. I mean, this feeling that you're feeling that it's a huge problem, yeah, because there's a lot of underreporting as well. That's probably the feeling that I think we all feel.
Thank you. Thank you, Senators. Senator Perez?
Thank you, Madam Chair, and thank you to the panel for being here. When I look at these numbers, the vertical statistics, it's pretty startling to me to see there's a 200% increase in the amount of cases in sexual offenses from 2010 to 2018. And the increase of the amount of registered sex offenders is about a 67% increase from the same amount of time. And just one offense has cascading effects on our population. I think definitely this, I don't know if we can say this is an epidemic. We need to really address this, make this a priority. I'm also, with the recommendations that you have come here today, I think those are important we need to highlight those people who are in our community that have committed these crimes. I think one is enough to be able to highlight them because my understanding is the recidivism is high. The other thing is there any connection to the sexual abuse that have taken place in the church, related to the church, and what's happening in our community? Is there any understanding or any studies that connect that?
The matters that are before the courts of Guam for the Archdiocese, those are civil in nature, and so the discussions that we have are all related to criminal offenses that have been brought before the court.
Yeah, but considering that sex offense can cascade in families, is there a connection, is there a relationship between what's happening with those victims and what's happening else currently today?
Okay, so sometimes whenever we see, so just in general, when we see a rise in something, so for example, I'll give autism as an example, right? So if you look at, say, 15, 20 years ago, the rate of autism for children, et cetera, was like, I'm gonna not make up a number, let's say 1 in 2,000. But if you look now, it's 1 in, I wanna say 80 some, or whatever the statistic that they give. A lot of it has to do with literally awareness, better diagnostic procedures, and really just due diligence by everyone to get people diagnosed and or to get these folks arrested or to get some charges. There's no doubt that the recent coverage, it's not even recent, it was like 20 years now with the clergy sex abuse scandals, it has opened the eyes of a lot of people, whether it's in the clergy or Boy Scouts or anywhere else. But I couldn't tell you if it's related, but I think that there's an increase, but the fact that it's covered everywhere, there's movies, Oscar-winning movies about these subjects, obviously that helps to get the awareness out and people report more. So that's how I see the phenomena, but I couldn't say specifically that because of the awareness and maybe because of the sex abuse scandal that there's more. I think it's always been there. I just think that we're just identifying folks more and really getting after these people.
Are there federal grants available that you know of that can help with this problem? There are the federal grants out there that can create safer neighborhoods.
From even before I came full-time to the courts, the idea that the federal government or anyone or citizens want to pay for treatment for offenders in prison is not a popular thing. Okay, so but what's happening now, because what it used to be was there's a lot of money going for victims, victim rights. I mean, we're talking, billions of dollars going for victims. There is, however, now a movement toward, well, the reason why there are a lot of victims is because we're not really tending to the offenders. So specifically, I can't tell you what money is available, but there's definitely a shift, and I've seen this where there is more money to be given for offenders. Where I would look for money would be obviously the folks that are in jail. I know there's some stuff going on, and the court actually paid for the CBISO and brought in we trained a lot of the other folks from other agencies. But no doubt there's money out there to help the folks that are inside, so when they do leave, there's a much greater chance that there won't be any reoffending for everything, and not just sex offenders, for all kinds of offenses, especially domestic violence as well. That's just huge.
Senator, if I may just also, I think we provided in your packet, it's the Bureau of Statistics and Plans information. That's because of a grant that was being applied for, so it tells you exactly what they want in that grant, what type. They're looking for law enforcement, offender registry management, and different things. So yeah, I think we'd have to be very specific which area it is that you're inquiring about. But perhaps I'm trying to think of, but maybe if we just did a call out to all the agencies, we would hear where their grants are, which grants they are looking at. I guess if I may, sorry, Senator, but if I may just add, if there are any that you're looking at to increase what you are doing now, that's what we would be interested to know. Especially, we feel there's an urgent need, so if you have an urgent request in for additional grant funding to address any of these issues that have been brought up, then please bring that to our attention, any of the agencies.
Okay,
Senator Perez, please
yes,
proceed.
one more question. So what's the effectiveness of the treatment for these sex offenders? So the current treatment that you have for them, can you explain that again?
Okay, so I wasn't trained on it. It's CBISO, so it's a cognitive behavioral interventions for sex offenders. It's a 52-week program. It's quite comprehensive, and it covers all areas of psychological well-being, attending to your negative thinking, and all those things. How effective is it? I don't know the data on that. I just think that I know from the last time we were here with a roundtable, there just wasn't enough offenders to make a real good opinion that this is effective, because sometimes they drop out, they get released. So the data that they had on the CBISO effectiveness in the states and other things, we could get that to you. We can find out how effective is it. I'm assuming that if we got money for it, and it's a pretty good evidence-based treatment. I don't know anything else that's going on in the DOC in terms of other treatments.
Senator, if I may add also, at the roundtable, that's the question we wanted answered, and so we had asked for all of the agencies present to also report back to us, particular DOC who's implementing the program. We asked behavioral health to also report what they know about that program, or if they had a recommendation as to another treatment that is more effective that they recommend for Guam. So we want the hard recommendation from the courts, from DOC, from behavioral health. I can't remember who else we had asked, but from them to tell us, is that their recommendation still? It only began in 2017, that program, that's why. So yeah, kind of too early to tell, not enough. We'll see. I know they have to report back on their grants and they can submit that to us, but what we wanted was further than that. We want their recommendation as to the most effective program that they recommend Guam invest in.
Okay, and even, I remember we also, when we were here at the round table, I do have some assessment information. I'm going to go and give it to you for the record. I want you guys, the senators, to have it. Anyway, it's nothing mysterious. It's just off some websites regarding assessments for sex offenders. Because even before treatment, Senator, assessment is key, and I said this at the round table. So you can have all the programs that you have, but if the person is not an appropriate referral to a treatment, what are you treating, right? So one of the problems that go with this area is that every sex offender, it's a heterogeneous thing. You have people who are dyed-in-the-wool pedophiles that will never change, and there are those who are almost like in the middle ground, and then those who are just maybe starting. Then there are those who are maybe got caught up in some just terrible situations, and every single one of them would have different needs, psychological needs. So what you want to do is assess better. So what they do have, and you'll get a copy of this, I'll give it to the chair, and it's everything I talked about the last time.
Yes, we've asked the courts for a hard recommendation as to which assessment we should go with. So, yeah, I'd appreciate that in writing, and we will definitely give that to all the senators. That's because we feel like they're the best to make that determination, but yes.
The other thing I want to add is in the schools, I mean, what kind of preventive education is going on in the schools, before any of this starts, right?
I think that some of the preventive measures in the schools is the Attorney General's office perhaps could answer that more. The good touch, bad touch, and then that's what we see a lot more reporting going on now. The Department of Education has their own data source, and so perhaps, I know they have a mandatory duty to report, but we are not, other than the programs that the judiciary partners with, like Play by the Rules and our bullying prevention programs out there, I don't know of any other programs that are mandatory in the school setting for public and private schools.
I think there's and I don't think we have it here, or we ever applied for any grants, but just the idea about general safety is probably a good thing. So you always go in pairs, dark places, just some general rules would probably be good. But I know there are people that can come and talk about those issues in school or whatever. I don't know if there's any programs though. Just general safety stuff.
Yeah, maybe it's probably best to hire new personnel to, assess the students. Is there any particular position that you're aware of that would be good to implement in our schools?
I don't know if anyone else knows. The idea would be that I just realized that, if you think about it, every place should have a safety assessment in terms of, to lower victim chances and to become a victim of crime. There are lots of private people who can do these trainings and things like that. I know that some organizations have probably set up their safety assessment. Dark places, someone should say, well, an engineer needs to move this wall, or because some people could get victimized here and there. Schools might have a safety assessment of places that are dangerous for kids. So there are a lot of people out there that can do that. I can't tell you right now. Just safety assessments. I don't know if that was your question, Senator, I'm sorry.
Yeah, I was thinking along the lines of more of a counseling, emotional counseling assessments, what's happening in the family.
I quit teaching in 2016. I was an educator at George Washington High School for about 10 years. And when I came forward in the media after my attack, I did have several students come and confide in me. And of course, like you indicated, we are mandatory reporters. However, I can tell you right now, I don't know if it's changed since then, but I was not given any formal SOP on what I needed to do as a teacher in order for me to effectively help the student out and report it. And I actually had to figure it out on my own, who to contact. I worked diligently with the school counselor on just making sure that all of my bases were covered. So I think that even within the GDOE, unless it's changed since I've been there, I wasn't informed of any protocol or procedure on what teachers need to do in order to properly, once a student identifies with them, how to properly report it and what the chain of command is and all of that. And like I said, I stopped teaching in 2016. So I literally had to figure out that system on my own with the help of some of the counselors.
Thank you.
Yeah, having been a former instructor myself, so along with that, and I think you're on the same page, but just to make sure that it's included with what you were saying is having that training in learning how to identify, so that the reporting, the help, all of those things were there, but also learning how to identify the behaviors. So I definitely support that kind of training. And since we're talking about the possibilities of the website, I just wanted to include one more that was passed on to me. Is it possible, or I'd like to see if it's possible, again, to really understand these differences, level 1, level 2, level 3, those mean a certain type of a thing. But for those of us to understand which ones have had victims under the age of 16 or 14. So I don't know what the possibilities are, but I think as a parent and a grandparent, those things would be really important to understand, because it seems like from our last roundtable and other information that they operate differently, and then of course they look for specific types of victims. So if you could consider that as well.
I think we're done with our questions, but is there anything you would like to add before I summarize and close?
Just the other thing we were asked to look at with respect to providing the pre-sentence reports. So
Oh, yes.
you may want to look at the statute, right? Because I alluded earlier that there's a statutory provision that talks about the procedures of providing the pre-sentence report to the judge and to the lawyers involved in the case at the time of sentencing.
Yes.
And that those reports be returned immediately back to the court and are confidential. So that is perhaps something that you may want to look into to see if you can reconcile that with the other provision that says when they're going to be released on parole.
Right, should be available.
That
Right.
should be made available. Yeah.
Thank you. Yes, those are very helpful. And so, Dr. Rapadas.
And just one last thing. So if I'm going to give you the recommendations for assessment tools,
Yes.
Obviously I'll put some costs, because then you're looking at if you're looking at an island-wide help for agencies, it's probably not a giant sum, but a pretty good amount of money for to do proper assessments. Just to let you know.
All right. I want to thank all of you for being here, most especially Chief Kinata, because it's Customs Week, or Corrections Week, rather. It's not Customs, Corrections Week, and I know that they are very busy up there having different activities. So thank you for your time here. I think it's been very well spent, and I want to thank all of you for the contributions that you've made. So we are looking again at whether we can implement effective rehabilitation or treatment, and if there isn't one available or currently available, we must incorporate that reality into our decision making regarding release. Ultimately, we want a risk assessment tool that can be used across agencies, determining risk of repeat offenders in criminal sexual conduct and risk against minors, if that would be ideal also. We want to prepare to monitor criminal sexual conduct offenders whose prison terms may be ending or who may be eligible for parole, in addition to what is being currently done. Regarding the registry, our goal here today is to find, the goal of the registry is to find these offenders if anything has happened in the community that might make them, suspect. We want to be able to locate them right away. We want our community to also be safe. And in order to be safe against repeat offenders, we want to know who they are, what they look like, where they frequent, if possible, everything that we can possibly know, and find creative ways, as is done in other places, to ensure that the community is made aware. And in particular, we can focus those efforts on those who are high risk of reoffending. That would be well spent, I think. Of course, we want to help law enforcement in their efforts to ensure that there's compliance in all your efforts. Compliance in registering, first of all. Compliance in the parole terms, if those can be shared, I think that would also be helpful to the community. Same thing with probation terms, right? Just so that we know, oh, this person's not supposed to be hanging out here at the bar with us. Maybe the probation officers need to know about. Whatever you think will assist you in your roles, I think the community is willing to help, but because we want success. We very much want success in preventing any further harm. We are asking you at the offender registry, and I thank my colleagues for their excellent questions and suggestions, and your excellent questions and suggestions also. So if we can see if we can increase monitoring efforts, what would it take to do that? Increase the availability or the convenience of the information that is being provided for our community, and if we can push that out a little bit more with our community efforts, I think those would all help. And again, thank you. Yes, yes, Mr. Payuma?
Yeah, I just wanted to clarify.
Sure.
When we spoke about those 4 operations each
Right.
year that we do, those aren't the only times we are out in the field checking addresses. That's just the collaboration that we do with the U.S. Marshals that week. But let's say, for instance, an offender comes in and reports a new address tomorrow. Our next scheduled operation is in August. We won't wait till August to check that house. Within the next 2 weeks, we'll be out there making sure that the address is correct, and then we'll have that sheet or that address on our list also in August. So this happens throughout the year. The 200 visits I spoke about that we did in 2019, 100 of those were made with our first operation in March, but the other 100 were just within probation alone. So we go out daily. We may do 4 visits in one morning or in the afternoon, but this is constantly happening throughout the year. Just want to make that clear.
I really appreciate that. Thank you. That's very reassuring to hear.
Yes. I think the more the community can be assured that people on the registry are being monitored in general, and that we are aware of their locations, and we are aware of things that would be helpful to prevent, any new victims. That's what we want. So I appreciate your efforts in that regard. So I want to thank you again for being here, and thank you all for your time and your efforts in this regard. So this concludes our hearing today. And if there is any further testimony that you'd like to provide, please send it to senatorterlajeguam@gmail.com. Public hearing is now adjourned. It's 4 p.m. Situs Masi.